So we are still in the First Amendment. We're talking about First Amendment protections, and we have talked about freedom of speech, and we have talked about freedom of the press. We just have a little bit left to go. So let's just talk about a little bit about freedom of assembly, which is another part of the First Amendment. And we colloquially call it freedom of assembly. The words in the First Amendment said the right of the people peaceably to assemble and to petition the government for redress of grievances. There were many examples of the people in the colonies having unrest and telling Great Britain that they did not like the way that they were doing things. They did not like the taxes that they were putting on people. They did not like the way that they were treating people. They did not like having to quarter soldiers. And so they definitely wrote the ability to not be criminally charged when you decide that you were going to tell the government, I don't like what you're doing, into First Amendment protections. And we have a hard time with this one. We have a hard time because there are things that people are saying that we don't want to hear. But it does not say in the Constitution or in any common law that we have to like what they say. In fact, you have the absolute right to peaceably assemble and petition the government for redress of grievances. We're not going to talk about a whole bunch of cases. We're really just going to talk about one. And that is the Skokie Nazi Party case. And so let me set it up a little bit for you, why this was so inflammatory. This is about as bad, maybe even worse. It's about as bad as Westboro Baptist Church showing up at funerals and saying, "Ha ha, you died because God is mad, and we're happy you're dead." So this was around the late 80s, early 90s. There was a white supremacist movement that arose. We used to call the people skinheads. They would cut their hair really short, leave enough hair so that they could put a swastika in their hair. And a swastika was the sign of the Nazi Party that was founded in Germany. Now, the Nazi Party, in case you don't know, was headed by Adolf Hitler. And Adolf Hitler believed that pure Aryan people, preferably blonde hair, blue eyes, were superior. So there's that. And that Jewish people did not deserve to live in society. And so he set about eliminating Jewish people, first from Germany, but anywhere that he could. There were things called concentration camps all over Europe. And he would actually round up people of Jewish descent, men, women, children, and ship them off to these camps, take their clothes, take their belongings, and force them to live there. Sometimes they would labor there, and they did experiments on them. They would round up large groups of people and put them in gas chambers and just kill loads and loads of people. It was really part of what we were trying to root out during World War II. America fought really hard to stop this action and to rescue the people that were being so brutally, just killed. Thousands of people. Um, and so for you, white, mostly male group, to say we like what they did, we are supporters of that same idea, and we really would like to bring that back. So you were these new Nazis. This group decided that they wanted to have a demonstration, basically an anti-Jewish demonstration. And the place that they wanted to have it was in Skokie. I think Skokie is in Ohio. The town of Skokie had a very large population, large percentage of people that were of Jewish descent. Many of them were actual survivors of the Holocaust in Germany or the Holocaust itself, or were family members, descendants of people that had survived the Holocaust. So they decided that they wanted to have an anti-Jewish demonstration in the town. And the town said, no, you're not coming to Skokie, because really all you were trying to do is provoke people. This is not going to end well. You are causing a lot of hurt. We don't like what you're saying. So, as you can imagine, the party sued the city. And the case goes up to the Supreme Court, and many people thought that they were perfectly within their rights because they were trying to avoid undesirable consequences. But the Supreme Court ruled, once that case finally got there, that your right to assemble takes precedence over some possible undesired consequence, and really over the what you're saying, the content. Now, just like every other part of the First Amendment, or every other part of the Constitution for that matter, there are exceptions to the absolute right to assemble and petition the government for redress of grievances. We call these restrictions time, place, and manner restrictions. So if there are rules for having a demonstration, they, number one, have to be content neutral. You can't decide, well, I like what you have to say, so you can come, but I don't like what you have to say, so you cannot do that. Has to be content neutral. But you can say you have to get a permit to be able to have an assembly, as long as you are requiring everybody to get a permit, and the amount doesn't change based on who is applying. You can say that all assemblies have to shut down at midnight in our city. You can say you can't march in the middle of a street. You can even say you can't go to someone's house and protest outside of someone's private residence. You can say manner that you cannot disrupt, you cannot destroy property, you cannot hit cars, you cannot walk in the middle of a freeway. So you can have restrictions as long as they are content neutral. They are applied fairly to all groups, no matter what issue they are protesting. You can't tell one group it's okay for you to come, but you can't. So there are justifiable and legal restrictions that are permissible, and that is time, place, and manner restrictions. So that's all on freedom of assembly. Let's talk about specifically freedom of the press and prior restraint. Now, we talked a little bit about prior restraint in the Neer versus Minnesota case when we were talking about selective incorporation. That's been a while ago, where Mr. Neer had been writing these horrible articles about public officials and saying that they were part of the Jewish gang and that they were stealing money, and he was doing it in a series. And he was ordered by the city to stop it under a state law that said that they could tell you you can't publish certain things if they harm people's reputation. And Mr. Neer continued to publish them and got arrested. And eventually his case went to the Supreme Court. And the Supreme Court said you cannot have a law that tells people what they can publish before they do that. That is called prior restraint. Another way to say that is censorship. And censorship is specifically prohibited in the United States, and it was one of the first things that was incorporated. So fast forward to 1971, and really everything, unlike a lot of the cases that we've talked about, everything that happened in this case happened all in that year. It was actually pretty fast moving. And that was the case of New York Times versus US, or the Pentagon Papers case. Now notice at the top of this slide, and even in the book, they have the word libel there. There is another case that is called New York Times versus Sullivan that is a libel case. New York Times Company versus the United States is not a libel case. It is a little confusing. It is not a libel case. It is a prior restraint case. So let's make sure that we keep them separate. New York Times Company versus US was the result of a guy named Daniel Ellsberg. Mr. Ellsberg worked for the Department of Defense, and he had been given an assignment during the Vietnam War to embed himself, interview, and look at morale, look at theory, look at strategy, and come back and report how things were doing. So Mr. Ellsberg did just that. He goes and he files his report, and it was a pretty dismal assessment. He basically said that morale was bad, that soldiers were disillusioned because they didn't exactly understand why they were there. It was hard to determine who the enemy was, that the strategy seemed to not be working. Certainly it wasn't resonating with the soldiers. They were having health problems. He really just kind of laid it down. And he files his report with higher ups, and they look at it and they said, we understand. But what ends up being reported to the American people was everything's great. Everything's great in Vietnam. We're winning in Vietnam. Morale is great in Vietnam. There are no problems in Vietnam because President Nixon really did not want to have a bad assessment going forward. He's getting ready to run for re-election. He didn't. That was not something that he was excited about. So Mr. Ellsberg decided that he was going to let the American public know the truth. And so he started retrieving his own report, but this was the property of the United States. he started retrieving his own report and giving it to the New York Times. And the New York Times started publishing a series where they were actually showing the wording of the papers that Mr. Ellsberg had written. They were giving it to the American public, and they, it's like, stay tuned, we have some more tomorrow. And so people are reading this. This is explosive. They're like, how did you get this? They're like, this is horrible. And people were already starting to doubt the Vietnam War and the efficacy of the Vietnam War, but now they were seeing that they were also being lied to. So, President Nixon filed what's called an injunction, a request for an injunction. And he looked to get the Supreme Court to order the New York Times to stop publishing this material, because after all, it was classified material. So in the meantime, the Washington Post, someone at the Washington Post figured out who was giving the information. So while New York Times was on pause, the Washington Post started publishing the information. So President Nixon also filed, or had the Attorney General file, an injunction against the Washington Post. And so it said, you cannot publish anymore. This is a matter of national security. This is about the war effort. This is classified information. There's no way that it is okay. So the Supreme Court has in their hand a prime question of, can we tell these newspapers that they cannot publish? That's prior restraint. And they decided that even though the material was obviously not obtained legally, meaning Mr. Ellsberg did not have the authority to give that information, it was not his to give. Even in that instance, if they had it and they were publishing it, then they were not going to tell them not to publish it. It wasn't false. It was not about something, it was not revealing war secrets. It wasn't saying this is where people are going to be next week so that our enemies could come and read it and have a handbook of what they were doing. It was talking about things that had happened in the past, and really was not talking about anything that had to do with strategy at all. It had to do with morale and how things were looking, and it had several quotes from previous presidents, but it was in the past. Now, was Mr. Ellsberg in trouble for other things like stealing government property? Oh, yes. Mr. Ellsberg was in trouble. But the New York Times and Washington Post were not going to be restrained. And they won. They won that case. That is how much the United States government hates prior restraint or censorship. We're not going to tell you that you cannot publish something. Now, can you sometimes get in trouble for what you do publish? You might get in trouble for what you publish. But we're not going to tell you that you can't publish it. One of the things that you can get in trouble for publishing is false information.
So we will,
if it is published, if it's written down and given to the public, we
make
call
sure
that
that we
libel.
do that. So the
Libel
last thing that
is
we
the publication
talked about
of false material that harms the reputation
last thing
of a person. It has to be false, it has to be published, and it has to harm a person's reputation. Slander is really the same side of that coin. It is just that it is said out loud. So like in news or said to a group of people. While libel is written down, slander is spoken, but they are still the same. Has to be false. It has to damage a person's reputation. There have to be some damages. And you can sue and recover, and a newspaper or a news outlet can get in trouble for libel or slander. They can pay a fine, have to pay a fine. They may have to apologize. They may have to print a retraction. All kinds of things can happen if it is found that what they printed was libelous or what they said was slanderous. So let's look a little bit at the law, at least the common law on this matter. The big libel and slander case is New York Times versus Sullivan. It's a 1964 case. Notice that it's several years before New York Times versus the U.S. And it has a slightly different style or title. So in this case, this was during the height of the civil rights movement, and specifically the civil rights movement which was happening in the South, where there were demonstrations, there were sit-ins, there were ride-alongs, there were many displays of resistance to change in the South. And the leaders of the resistance were very careful to make sure that it was documented, that this resistance was documented. We'll talk a lot about this in chapter 5. But after a particular incident in Alabama, Montgomery, Alabama, where pictures had been taken of police dogs and fire hoses being turned on demonstrators. A clergyman, a preacher, who, and a lot of preachers were very active in the civil rights movement, took out an ad in the New York Times. And in the ad, it basically was calling on the South to do better. And it said that the officials in Montgomery had not protected the civil rights protesters, and in fact had caused some harm. In the ad itself, there were some inaccuracies. There were some things that were not accurate. Now, the ad did not name anyone specific, but the chief of police in the city said, who else are the officials? You have to be talking about us. So you have now printed something that is false, that damages my reputation. Several city officials filed suit, not against the clergyman, but against the New York Times for publishing this information, and was seeking money damages for the damage to their reputation, for the false information. A libel suit. So in Montgomery, Alabama, it was an all-male, all-white jury. The New York Times lost, and the jury ordered the New York Times to pay the police chief and several other officials $500,000 apiece. Now, this is in 1964. That was a whole bunch of money. It's a whole bunch of money now, but it was even more in 1964. The New York Times appealed the case, and they lost in appellate court. They lost in the Supreme Court of Alabama, they appealed to the Supreme Court of the United States. And because it had something to do with First Amendment, the Supreme Court, using incorporation, selective incorporation, took the case. The Supreme Court decided that it just made no sense for public officials, elected officials, people appointed to high positions, to be able to sue every time somebody said something false. And so they decided that if you were a public official, you're the police chief, you're the mayor, you are the governor, you are a public official, that it is not going to be enough to just show that there was something false and that it harmed your reputation. So after the New York Times versus Sullivan case, the court said the new common law, and remember, we treat this just like law. This is still common law in the United States. If you're a public official, you have to prove something extra. You have to prove that the statements that were false were made with actual malice and reckless disregard for the truth. So you have to prove more as a public official. You have to get some thicker skin. Because unless the person knew the truth, they were presented with the truth, and they said, nope, we're not printing the truth, we're printing this incorrect information because we don't like this person. And how do you prove that? Then you lose as a public official. It is very, 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 very difficult for a public official, an elected or high-ranking government official, to win a libel or slander case, because they have to prove something extra, that it was done with actual malice and reckless disregard for the truth. Eventually, this same court, and this was the court under Earl Warren, decided that they were going to extend this to public figures. So you don't have to be an elected official. You don't have to be somebody that is running government. You can just be somebody famous. If you are a household name, you are extremely famous, you also have to prove that false statements that are printed or said about you are made with actual malice or reckless disregard for the truth. It is very difficult for celebrities to win slander and libel suits. So they changed the law, and there was a period of time in 2016 when President Trump was saying, really, really, we need to get away. We need to do away with the New York Times versus Sullivan standard. Because we should, as public officials, not have to take false information and just have to live with it because we can't prove that it was done with actual malice. So those are the libel and slander cases. We also talked about freedom of assembly, and that ends freedom of speech and freedom of publication for Chapter 4.